This video focuses on just a little bit of background information about the Supreme Court. There's definitely some overlap with some of the stuff we talked about in Fed 78 as well. All right. First thing is there's no specific mentioning of the number of Supreme Court judges that need to exist in the Constitution. So the Constitution is like silent on this, right? This means that ultimately this had to be determined generally by like acts of Congress. So the original Supreme Court had 6 justices. At points in time, it's been lower. So, for example, it was reduced by an act of Congress in 1801 to 5. And there has been 9 ever since 1869. That's currently what we have on the court now is 9. So again, it's important to note that this number is not set in stone. It can change depending on like laws passed by Congress, but it hasn't changed in a really long time. So, I mean, there have been attempts to do this. Like, so for example, in 1939, President Roosevelt, at his urging, uh, was trying to get Congress to pass what was called the Judicial Procedures Reform Bill. This is often known as Roosevelt's court packing scheme. And basically, one of the things that this would do, or one of the things that Roosevelt was experiencing, was major opposition on the Supreme Court to many of his programs to like pull the country out of like the depression, and deal with like the economic problems of the day. There were more conservatives on the court that essentially were blocking his programs. So one of the things that this bill would have done is it would have given him the ability to appoint a new Supreme Court justice for every justice that was over the age of 70 already on the court. So this is often called court packing because this would give him the ability to appoint people that thought very similar to him on issues and would ultimately make it easier for his programs to go through. Now, this law was not approved, and you could argue that the danger with court packing is if the Democrats did it this time, what would stop Republicans from doing it when they took control of the presidency and Congress, right? So I think most people recognize this was a bad idea, and that's why ultimately it wasn't approved. Other key vocab terms, again, this is generally a review of Fed 78, is that, we've talked about the fact that the Supreme Court does possess judicial independence. The idea was like the structure of the court, basically through the appointment process, and then not having them having to be reelected, basically allows the judges to make decisions that are correct legally and not really what's popular at the time. So again, the Supreme Court possesses judicial independence, and that keeps them from being unfairly influenced by outside forces when they're making their decisions on cases. And again, the two ways that judicial independence is most often achieved easily by Supreme Court is that, again, they are appointed by the president, not elected, and then they don't have to like come up for like reapproval. Once they have their job, they have it for life. And that also, obviously, we've talked about that it's the role of the courts to really determine what is constitutional and what is not. It's also important to remember that that's not specifically in the Constitution. One of the mandatory Supreme Court cases that you must know is Marbury versus Madison, and it's really not important for this case to go into like great detail about the case itself, just to know that this is the case in which the Supreme Court gave itself this power of judicial review. From 1803 on, it had become the job of the Supreme Court to review decisions or laws passed by Congress or actions taken by the president and determine if they were constitutional. This is not something that was specifically provided as a power in the Constitution. It's something the Supreme Court gives itself in the case of Marbury versus Madison.